Greetings from Edu Aspirants, our YouTube channel to ace academics, competitive exams, entrance exams, as also for enrichment of knowledge. In the series of videos on India, in the 21st chapter, let us see what we have for you in Law and Justice, video 2. Judiciary, at the apex of the entire judicial system, is the Supreme Court of India, with a High Court for each state or group of states, and under the High Courts there is a hierarchy of subordinate courts. Panchayat courts are also functional in some states under various names like Nyay Panchayat, Panchayat Adalat, Gram Kacheri, etc. to decide civil and criminal disputes of petty and local nature. The highest court in each district is that of District and Sessions Judge. This court is the principal court of civil jurisdiction and can try all offences including those punishable with death. Below it there are courts of civil jurisdiction known in different states as munsifs, sub-judges, civil judges and the likes. Similarly, criminal courts comprise Chief Judicial Magistrate CJM and Judicial Magistrate of first and second class. Supreme Court. Government of India Act 1935 introduced a federal constitution to India involving distribution of powers between the centre and the constituent units. The Federal Court of India began functioning from October 1, 1937. Federal Court had a very limited jurisdiction confined to original jurisdiction in disputes between the centre and constituent units, or amongst the latter, advisory jurisdiction and appellate jurisdiction on a certificate from the High Court. Supreme Court continues. After achieving independence in August 1947, there was demand from the Indian polity for enlarging the jurisdiction of Federal Court and granting more powers to it. So what happened? On January 26, 1950, the Federal Court gave way to the Supreme Court of India under the new constitution. Some more on Supreme Court. Supreme Court is located on Tilak Marg, New Delhi. After its inauguration on January 28, 1950, the Apex Court commenced its sittings in a part of the Parliament House and moved into the present building on August 4, 1958. The original Constitution of 1950 envisaged a Supreme Court with a Chief Justice and 7 judges. The Parliament increased the number of judges from 7 in 1950 to 34, which is now, including the Chief Justice of India. So 33 plus CJI. The Supreme Court of India comprises the Chief Justice and 33 other judges appointed by the President of India. Supreme Court judges retire upon attaining the age of 65 years. In order to be appointed as a judge of the Supreme Court, a person must be a citizen of India and must have been for at least 5 years a judge of a High Court or of 2 or more such courts in succession, or advocate of a High Court or of 2 or more such courts in succession for at least 10 years, or he must be, in the opinion of the President, a distinguished jurist. Provisions exist for the appointment of a judge of a High Court as ad hoc judge of the Supreme Court, and for retired judges of the Supreme Court or High Courts to sit and act as judges of Supreme Court. The Constitution seeks to ensure the independence of Supreme Court judges. A judge of the Supreme Court cannot be removed from office except by an order of the President, passed after an address in each House of Parliament supported by a majority of the total membership of that House and by a majority of not less than 2/3 of members present and voting, and presented to the President in the same session for such removal on ground of proved misbehavior or incapacity. A person who has been a judge of the Supreme Court is debarred from practicing in any court of law before any other authority in India. The proceedings of the Supreme Court are conducted in English only. Supreme Court Rules 2013 replaced the 1966 rules, which were framed under Article 145 of the Constitution to regulate the practice and procedure of the Supreme Court. High Courts. High Courts are concerned with the judicial administration of the states. There are 25 High Courts in the country, 3 having jurisdiction over more than one state. Among the Union Territories, Delhi alone has a High Court of its own. Other Union Territories come under the jurisdiction of different state High Courts. Each High Court comprises a Chief Justice and such other judges as the President may appoint. The Chief Justice of a High Court is appointed by the President of India in consultation with the Chief Justice of India and the Governor of the state. The procedure for appointing the High Court judges is the same as the Supreme Court of India, except that the recommendation for the appointment of judges in the High Court is initiated by the Chief Justice of the High Court concerned, not the Supreme Court of India. They hold office up to 62 years of age. To be eligible for appointment as a judge, one must be a citizen of India and should have held a judicial office in India for 10 years or must have practiced as an advocate of a High Court or 2 or more such courts in succession for 10 years. Power of Supreme Court and High Courts. Supreme Court has power to issue any person or authority and government within its jurisdiction, direction, order or writs, including writs which are in the nature of enforcement of fundamental rights and for any other purpose. This power may also be exercised by any High Court exercising jurisdiction in relation to territories within which the cause of action wholly or in part arises for exercise of such power, even if the seat of such government or authority or residence of such person is not within those territories. This brings us to the end of the second video on law and justice. See you with the next video. Please subscribe, like, share and do press the bell icon for updates. Keep revising. You will have questions in your forthcoming exams too. Thank you for viewing and best of luck.